Jim and Carol Peterson had done everything right. They had wills, they'd talked to an attorney, they'd updated their documents when their kids were born. This is a case I've seen in different forms many times. When Carol passed away, Jim assumed the transition would be straightforward. What the family didn't expect was a bill, not from a creditor, not from a lawsuit, from the probate process itself. By the time the estate was settled, they had paid just over $35,000 in court fees, attorney's fees, and the personal representative's fee, and it had taken 14 months. Now, details have been changed to protect privacy. The will did not protect them from any of it. Now, let me be straight with you. $35,000 is not what every probate costs. For a simple estate, it might be a few $1,000s. But the Petersons had more: a home, retirement accounts, and a second property up north. But probate costs scale with the size of the estate, and they're almost entirely avoidable. Now, whether your number would be 3,000 or 35, this matters to you. So what is probate? It's the court process that proves your will is valid and supervises distributing your estate. And three things about it surprise almost everyone. First is the cost. In Minnesota, by the time you add up court filing fees, attorney's fees, the personal representative's fees, and the required newspaper publication, probate commonly runs around 2 to 3% of the estate's value. And on a modest estate, well, that's a few $1,000s. On a larger one, with a house, retirement accounts, a cabin up north that can climb fast. And that's how a family ends up at $35,000. Second is the time. Minnesota probate typically takes 12 to 18 months. The law requires a 4-month window just for creditors to come forward, and that's the smooth version. A contested or complicated estate can stretch for years. And the whole time, the assets are often tied up in the court process and your family has to wait. Third, and this is the one almost nobody knows, probate is completely public. When your estate goes through probate, the court file is public record. So that means what you owned, what you owed, who gets what, the full inventory. Anyone can pull it up. A curious neighbor, a distant relative who thinks they were shortchanged. Anyone. And for a lot of families, that loss of privacy stings as much as the actual cost. So here's what the Petersons, would have experienced with one thing in place: a properly funded revocable living trust. A trust that actually holds your assets does not go through probate at all. That means no court, no 12 to 18-month wait, no public file. The successor trustee simply steps in, follows your instructions, and distributes everything privately. The process often takes weeks rather than months, not years. Now notice the word I keep using, funded. And this is where I watch plans fail. People pay for a trust, the document goes in a drawer, but the house was never deeded into the trust and the accounts were never retitled. An unfunded trust is just an expensive piece of paper, and the estate still goes through probate anyway. So what does funding actually look like? Well, for a home, it means signing a new deed that transfers the property from your name into the name of the trust. The deed gets recorded with the county, and from that point, the home belongs to the trust. For checking and savings accounts, you contact the bank and ask them to change the account holder to the trust. Some banks allow you to set it up as a payable on death account instead, where the trust is named as the beneficiary. Either way, the account passes outside of probate. For brokerage and investment accounts, the process is similar. You retitle the account into the name of the trust. The brokerage provides a form for this. It's paperwork, but it's not complicated. Retirement accounts are handled differently. An IRA or 401k should not be transferred into a trust directly. Doing that would trigger a taxable distribution, which most people want to avoid. So instead, you typically name the trust as the beneficiary or name a person directly. An estate planning attorney walks through which approach makes the most sense based on the size of the account and who the beneficiaries are. The point is this: every type of assets has its own transfer method. The trust document gives you the instructions, but someone has to actually follow through and retitle each asset one by one. That step does not happen automatically. Nobody does it for you. And it's the step most people skip, which is exactly why families end up in probate even when a trust exists. Jim's family eventually got everything sorted, but the 14 months, the legal fees, and the public court file were all avoidable. Jim now has a funded trust in place for his own estate. So when does a trust make more sense than a will? Well, if your estate includes real property, especially in more than one state, a trust avoids the need to open separate probate proceedings wherever the property sits. If privacy matters to you, a trust keeps your estate off the public record. If you have a blended family, a trust gives you more precise control over how assets pass and when. And if the cost and delay of probate is something you want your family to avoid entirely, a trust is usually the right tool. For simpler estates, a will paired with the right beneficiary designations on accounts and retirement funds, well, that can handle a great deal. The answer depends on what you have, how it's titled, and what you want your family to experience when the time comes. And that's a conversation worth having before the need is urgent, not after. So if you're curious what happens when a parent is diagnosed with dementia and the estate documents are not in order, well, that's my next video. The legal window to get things signed closes faster than most families realize, and I'll walk you through exactly what to do and when. And if you want to know whether your current plan would actually keep your family out of probate, call our office or visit us at rouletlaw.com. That's exactly what we check. And if you would like to discover more, join us in my upcoming masterclass, where I'll reveal strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And you can sign up by clicking the link in the description below. I'm Chuck Roulet. I look forward to seeing you in an upcoming video and the masterclass. Be well.